In terms of one of the cons is, I think Susheel made a good point about cross-examination. I think the quality of evidence that you get in cross-examination over a virtual platform is not the same as physical. I think that is a very important aspect. You know, witnesses are able to play a lot of tricks, and you know there isn't so much you can do. I'll give you an example. This was I was acting for one of the state entities of India actually, in a litigation in London, and one of the people we were cross-examining was a lady who was the CEO. So not very old. So we start the cross. I start the cross, and I can see her eyes darting to the right. And I ask her, is there someone in the room? She said, no, there's no one in the room. And I said, I can see a shadow. Oh, that was my son helping with the laptop. Okay, fine. Please ask your son to go out of the room. 10 minutes later, again, there is something happening. And then I tell her, why don't you just turn the laptop around? I'll have a look. Oh, I'm sorry, this is a desktop. I was just too nervous. I didn't realize. So you have a lot of these instances. Now, the Japanese, as the Japanese are, have developed a very interesting camera, which they'll put in the room. The control is with the judge or the arbitrator, and they get a 360-degree view. But again, that is expensive technology to have. Now, coming back to the experience, I think comparing the English High Court to the Bombay High Court or the Supreme Court, I think the judges there adapted quicker to technology. But when the Indian judges adapted, I think they were able to use technology better because they started imposing discipline, which sometimes doesn't happen in English courts. So in the Bombay High Court, a very common thing would be if the judge asked you to keep quiet, you're talking, the court would just turn your mic off, and then the other person starts. It was no longer that you turn up and it becomes a shouting match between two counsel, and then the judge after 10 minutes trying to pick up something says, okay, let's try and dictate an order and get out of it. So that was, I think, the big thing. As an arbitrator, and even as a counsel, one of the things that on a very personal level I realized, and a lot of my colleagues also agree to that, it is more strenuous to do an online hearing because your attention spans are shorter. It's very easy to lose yourself. And Susheel made a good point about judges, but equally as counsel, you're cross-examining somebody. It's very easy to sort of snap out of that concentration, and your mind can wander. Again, as an arbitrator, the pace goes down, you can sometimes wonder. When somebody is sitting in front of you, that connection remains, and it's very different that way.
Thank you, Vivek, for your insights. I can completely understand the tactics which people can play. So moving on to Navdeep. So Navdeep, I completely understand that you work for a premier law firm who's in arbitration, because I know Mr. Hero very well, and he's been on the arbitrator. He's been actually acting as an arbitrator for various corporates. So how has your experience been, wherein the litigation and arbitration online versus offline? And from your experience perspective, if you can share some insights, that'd be great.
Sure, I'll talk about this from two aspects. So first of all, of course, as a lawyer, it's made our lives very easy. There's no traveling involved, which was one of the largest headaches. But as a justice delivery system, arbitration is inherently expensive. And accessibility, in terms of accessibility, arbitration was always available to the big corporates. They could spend. But there is a whole other industry in arbitration on the lower levels, with financial institutions, with banks that exist in this country. And that has been averse to taking on this technology completely. And I think until and unless we actually impose some sort of technology and some sort of discipline on these lower sort of, I wouldn't like to call it lower, but this ignored part of the arbitration industry, I don't think the technology would help in actual delivery of justice. If we want to make this country a hub of arbitration, which we keep repeating in conferences, that level needs to rise up, and there the justice needs to be sped up, the delivery of justice. Because see, in India, delivery of justice is not in days, it's not in months, it's in years, and it's in decades. It needs to be in days for some ease of business and for it to become a true hub of arbitration. For lawyers like us, for all the corporates, it's always been accessible. We could fly. I mean, of course, it's made life very, very easy, and it's made life fun, and of course, we get to try much more cases. But I don't think the end result is that much different with the adoption of technology. I think the adoption of technology needs to be taken on to a whole new level for it to actually make justice delivery truly accessible to the litigant who is stuck in the process, for whom the process itself is a punishment. So I think that is...
I think, Navdeep, you made a very, very important point that the process for whom it is being made is actually becoming very cumbersome to them. So thank you for sharing your views. And I completely understand that it's been cost effective, but there are certain cons to it. So we'll then shift our directions to the academic piece of it. So Chirag wanted your thoughts on the same, and I think you've been associated with corporates taking their experiences also, and you as a academic person, you've read the law as well, and I'm sure being the center head, you might have seen a lot of great things. So just wanted to understand from your experience, online versus offline. So over to you.
Hello, a very good afternoon, everyone. Let's start from something very basic. What is online arbitration? Is it conducting an entire arbitration in an online manner? Is it about conducting some phases of an arbitration in an online manner? Like what Mr. Kapoor was saying, we could do filings online, we could do case management conference online, we could do e-discovery online, and still we can do the hearing in a physical form. A third way, to get the dispute resolved by an artificial intelligence. So the idea of online arbitration is a very multifaceted idea. And in order to understand it, we need to know the true color of arbitration. Arbitration is not just a mode of dispute resolution. Yes, it is adversarial, like litigation, but it is more of a business enabler. And once you identify its true characteristic, that it is a business enabler, the entire question, online versus offline, becomes redundant. You just simply ask a question that in a given fact, what is good for the business? And that could mean access to justice for the common person, or it could mean cutting down the cost for the corporations. Now, online arbitration, in whatever form we envisage, entire arbitration, only hearing cross-examination, e-discovery, whatever form we envisage, it's not a rocket science. Essentially, the medium has changed. The same goes with litigation. The medium has changed. What you were doing physically, now you are connected via device. And because of the change of medium, advantages and disadvantages flow. There would be concern now because you are using laptop, internet, there would be concerns related to cyber security. There would be concerns related to data privacy. But these are not the disadvantages which cannot be taken care of. For example, ICDR has laid down exhaustive protocol on cyber security and data privacy in online arbitration. There are protocols that if you have to do arbitration, there should be a certain size of internet bandwidth, which raises the question of accessibility to internet. And then another question, can I compel a party to online arbitration who is not willing to take part in online arbitration? Can online arbitration be compelled? There is a judgment of the Swedish court last year wherein they said, no, you cannot compel online arbitration. You don't know what is the accessibility to internet, you do not know what is the accessibility of device. Arbitration, as he was mentioning, though I may not completely agree, but yes, to some extent, it is for the elite, to some extent. And on top of that, you put internet, computer, technology. So what happened to the common man? If you compel that person, especially if that common man is compelled to do arbitration under standard form of contract, wherein arbitration agreement has been imposed on that person by virtue of standard form of contract. So these are some of the disadvantages which will flow. And there are some advantages which are already mentioned by my co-panelists: cutting down travel cost, accessibility, etc. I do not want to dwell into that. What is important to note about that you would find arguments what Mr. Kapoor was saying, that with respect to cross-examination, there could be tutoring. The answer of technology is with the technology. He mentioned 360-degree camera. It's expensive. You can use cheaper solution. You can put a mirror behind. If there is a mirror behind, you could have a 360-degree view. Mr. Jad was mentioning about that I'm not sure if an arbitrator is engaging or not.